Back to the afternoon session. I request all of you to settle in and get ready for a good round of more deep and engaging discussions. We now have with us this afternoon Joint Secretary Sri Gopal Krishnan, and he's the person who has been involved with convening the expert group that brought out the report on the free and fair digital economy and also the draft of the Personal Data Protection Bill. May I request Dr. Kathuria to please welcome Joint Secretary and share a few words.
Thank you, Gangesh, and welcome back from lunch. And as Gangesh said, that we're really privileged to have a special address by Joint Secretary S. Gopalakrishnan from MeitY, and as Gangesh said, that he's been involved in the drafting of the Data Security Protection Privacy Bill, which is going to be sort of discussed, deliberated, and I hope that by the time it comes out as law, it will have considered, all the comments and insights that civil society, other stakeholders have provided back to the government. So I won't take too much time, but just say that we'll have him speak for, 10, 15 minutes, and then engage. I think there's much more value added in engaging Mr. Gopalakrishnan, and we are really thankful that he's come out from his busy schedule and agreed to address us. So about 10, 15 minutes, and then we'll engage. Mr. Gopalakrishnan, the floor is yours.
The director, the team from ICRIER, and all the other stakeholders who are curious or interested on the data fraternity to be here on this workshop on the digital economy. Good afternoon to all of you, and I'm sure it's very easy to fall asleep in a few minutes now. Either the lunch is too good or I'm not making great listening. So that thing, this 10 minutes is a good excuse for me to curtail to the basics so that I could talk what is felt like more interesting. So in this digital economy future, I think there's no digital economy without data. And the approaches to data, we have seen drastically evolve, in fact, change drastically over the past few years, I should say. That's the first surprising part which I notice. And more than data, I think the first culprit was privacy. I mean, the focus for us first was privacy. And a few years back, the government informed the court that privacy, there's nothing called a fundamental right to privacy, etc. Then some years down the line, we are having the Supreme Court telling all of us again, no, privacy is a fundamental right. So your privacy is guaranteed. So now to ensure that we have in place a system which can sort of enforce this right to privacy, we have started on the path of working towards a privacy bill. And in parallel, things have been happening a lot across, particularly in Europe, in UK, and then the GDPR came active in Europe last year. And then similarly, last year, there was the California privacy bill. And right now, what I understand is for different set of motives, some very honorable, there's a proposal to come out with a federal privacy bill, which will probably sort of override the Californian bill. So this is the global perspective of what's happening. So as far as we are concerned, I should confess, I think all of you will appreciate that the arguments of or about privacy and thereby data was sort of colored by a huge elephant in the room, namely Aadhaar. So the identity program. So whenever there is a talk about privacy, identity, everything, we had to sort of, by de facto, people started to look at it from the lens of Aadhaar. And Aadhaar was again, or probably is still, not something which is unanimously popular or welcomed, etc. For some people, it reminds them of George Orwell. For some others, it sounds like a fabulous thing. So with such a Aadhaar mindset, I should call it, thinking objectively about, say, privacy or even the right to privacy becomes colored. Anyway, thankfully, a lot of stuff has happened. We've had a couple of significant Supreme Court cases. As part of the same case, actually, the Puttaswamy, the first verdict was on the privacy being a fundamental right. And then last year, there was another verdict on the legal validity of the Aadhaar program, both of which gave a lot of insights into what is probably in the mind of the court about the citizen's right to privacy, what are the court's concerns about what could go wrong, profiling and stuff like that. And also the court sanctioned that, okay guys, you can use it for genuinely developmental interested purposes. So in that path, the government set in place a committee led by a retired Supreme Court judge, Justice Sri Krishna, and a lot of members, largely official members. And so this committee went about its job. I would still like to repeat that the way it went about was something which is heartening, because even if people who don't agree with many of the things definitely had something good to say about the way it was done. Like somewhere around 2017, November, they threw out a white paper which sort of brought out all the issues, pros and cons. It didn't say that this is good or that is bad. It made an analysis of the whole privacy sort of knowledge base as on date with respect to all the countries across the world as on date, and then analyzed it in a legal angle. And then they had consultations, and then they came out with a draft bill on which feedback was again sought. I mean, we had feedback from more than 600 individual submissions, based on which it's almost nearing its final destination, namely a draft bill will go to Parliament, and after June, it will be taken up in Parliament, and for all I can guess, there's going to be more consultations, and then it becomes law. So ideally, in a topic like this, where it's almost like so many blind men and the elephant, what is the view of different stakeholders, what are the concerns, it's essential to have a repeated iterative discussions and feedbacks so that we can be clear about where we are headed. So such being the case, we are at a stage where the Personal Data Protection Bill may become law sometime over the course of this year. And again, we should clarify, I mean, for any of you who have been seeing the draft, it will be very clear. The focus of the law is on the individual and how to protect his or her privacy. Anything else is either relevant or incidental. The focus is on the individual. And to protect his or her privacy, you create a law for it, you bring in place a regulator for it with some adjudication mechanisms, some penalties, some practices. So everything is related to how to protect an individual's privacy. Now, if the privacy is not the core concern, then probably that provision probably doesn't fit in there most. So this is how I look at it. And on the other hand, in terms of concerns of stakeholders, there's been a huge variety of concerns, and some of it exaggerated, some of it solidly justified. There are concerns that this focus on privacy will kill innovation, data as the oil. No, all the oil will be sort of become captive or not available for everybody and stuff like that. Again, I would only suggest that please look at those concerns again from the point of view of the privacy. I'm not telling that there are counter thoughts. There are different schools of thought which think that, okay, we should treat data as a resource, otherwise we are going to be nowhere in the digital economy and stuff like that. But I would still say that's a different question for a different audience maybe, because our exercise so far in terms of bringing the data protection bill to this shape is more on the privacy. We do not have anything which can protect the individual's privacy against abuse by anybody who takes the data. So that is the minimum purpose which this bill seeks to achieve, and I think we still have some ground to cover. So that explains how far we have come, and we also realize that in our efforts to protect the privacy, we should also try to balance two other conflicting interests, one of which is like the growth of the data economy. I mean, you can't put in place so many speed breakers so that people can't innovate and sort of people find it difficult to get data, etc. And the other thing, again relevant, is you can't create hurdles to do business. I mean, you've got companies from across the world doing business in India, and you've got companies from India doing business in many countries. So this should not become some sort of unintended barrier where, to protect privacy, you end up adding to the costs and cumbersomeness of doing business. So that's where we see, I see a good role for harmonious sort of negotiations, where people tend to understand different approaches towards data. And if the basic purpose is like, okay, my citizens' data is protected in a different regime, then probably there could be much freer flow of data between those two regimes. But as in many other things, it's probably not something ready-made on day one, but I'm sure that's going to be the ultimate goal, because as long as that doesn't happen, we may not end up killing the internet or something like that, but it's going to make it much more difficult for companies to operate and data to flow around, which is the bedrock of the digital economy. So those concerns are definitely valid, and I'm glad to see in bits and pieces, different countries are also taking up such approaches so that these walls are sort of brought down before they grow into much bigger Chinese walls and stuff like that. So there's a lot more to be done. But I would close with just another small comment that data is like relevant to almost everybody. There's nobody who can say we don't relate to data, it's not my business. Every ministry, every bank, every department, every company, every employee, every employer, I mean, everybody is somebody who's going to be hit, affected, influenced by the data protection law and any other legislation or practices related to data protection. So this is going to be a very active turf where there's going to be a lot of currents and countercurrents. So with a good regulator in place, with a valid law in place, and with the courts looking at it in a positive frame of mind, I'm sure the data protection law could come into place to lead us towards a good and harmonious digital economy. Thank you.
Thank you, Mr. Gopalakrishnan. Would you like to?
If anybody is
awake. Yes. No, they're all, I think they're all wide awake, I think. And I think it's a very helpful and a constructive way of sort of providing a frame for the discussion. I think focus on the individual. You don't want to sort of negate or eliminate innovation, but privacy for the individual is important, and let's do it in a way that promotes economic growth, that promotes data flows, that promotes innovation. I think that's a very helpful and a constructive framing of the discussion and debate. I think the other thing that I just want to say before I throw the floor open is that, often, and India, and this is sort of a very general comment, is that between the private and the public, there has been elements of suspicion, of distrust, mistrust, however, and it's not only an India-specific thing, but it happens across the world. There's been this trust deficit, as we say, and digital economy provides an opportunity to either exacerbate that or to sort of reduce, perhaps even utopian comment would be to eliminate it, but even without going to that, at least reduce the deficit between the state and the people. So this is an opportunity, or it could just worsen the thing completely. So framing the debate in a way of let's protect the individual data privacy and yet not sort of undermine data flows, and it's a challenge and growth, but I think it's a very helpful construction of a framework. With that, let me sort of open the floor for questions. Yes, please. Yes, a question to Mr. Gopalakrishnan.
Yes, okay. This privacy is apparently caught between dystopia and utopia. Will you spell out what is actually privacy, which is harmful or which is good? Because we are talking about in a very vague terms about privacy.
Sir, I think, correct me, my concern is more like bringing in place a system which either minimizes or avoids harm. It's very difficult. See, the only benefit I can see is like absence of harm or relief if you are harmed, either a grievance, redressal, or a compensation. But the idea is privacy, if violated, can cause you harm. It could be at a very simple level like an unintended phone call, and it could be a major scam. So I think the basic thing which we want is, in today's technologically connected society, it's very easy for somebody else to intrude on your privacy. Now, whether you are harmed is a different question. So, I mean, the elements of easy harm, like somebody accesses my account, my bank, my passbook, I mean, obviously it's a harm. But it could be much more also. I mean, I just don't want my face in all the Google pages. I mean, I'm just joking. So, the purpose is to ensure that the citizen is not harmed. I think that's the basic approach of looking at privacy, and not to look for any other benefits. Sir.
Suppose an insurance company wants to know about a potential person who is going to be insured, what kind of disease he is having. So what do you think? Is it an invasion of privacy or what?
No, I think I'll clarify, sir. Privacy, bringing good privacy principles into place simply means don't change anything which is, I don't want an insurance company to insure you without knowing that you're at this stage of cancer, you're smoking and all those things. All that is essential, sir. But before you give your data to anybody, somebody should tell you what he or she is taking from you and what they will do with it and what they will do to you or with whom they will share with it. These are the basics. Today, so much of data about you is being taken across the place without even us knowing. I mean, if you're on the mobile phone, what the apps do with services, with sort of access to your contacts, to your messages, to your behavior. So, I mean, I'm not tired of repeating like this. We are moving towards an economy where it's called surveillance capitalism. It's not my term. There's a lady called Shoshana Zuhoff who brought it out. She teaches, I guess, in Harvard, and it's called surveillance capitalism. So the whole economy is moving towards, I will give you better service for which I need to surveil you. In the sense, you give me permissions to monitor what you do. I give you better service, but that's probably like 10% or something. Baki 90% about what is called your behavioral data. There are millions of guys willing to pay for it. So I'll sell it. So that's a basic violation of privacy if I do it without your consent. So even if you say, I don't care, there are arguments, very funny arguments which people say, like for Indians, privacy is something alien. Indians don't have privacy concerns, etc. Two guys sitting on a train will know each other inside out by the train reaches the station or something like that. All that is nothing to say ki we can give the goodbye to privacy. So that's why, see, look at this. If so far we've been lucky, it's because we've been less harmed. I mean, there are people who've been harmed. But the way things goes, if there is no privacy law, the harm is going to multiply megafold. As it is today, it's possible for somebody on the net to find out how much you are loan worthy. Nobody has taken any consent from you. We can just do a trawling on the net and find out कि भाई आपको अभी कितना तक loan दे सकते हैं. This is a major risk, I should say.
Yes, no, Rajkumar, the lady, please, yeah, she had her hand up first. Yes, please.
Well, I'm Sadhna from the Department of Science and Technology, Government of India. I have one question, that this draft PDP bill, how would it address vulnerability caused by wearable devices. See, these days we are all becoming fitness freak. We buy Fitbits, and these are loaded with softwares which carry some parameters, and automatically if softwares are altered to add more features, how will we address that? Because the current clauses 90, 91, 92 do talk of offenses and how it will be dealt. But what would be your treatment for this issue? Secondly, the issue of consent sometimes is in question. Especially many a times, today we have smart cars. The dashboard is equipped with many features. And when we are using, the consent issue really doesn't figure in our usage. How would our PDP bill address the consent which is automatically assumed as a user? That's all.
Can I, Mr. Gopal, just collect some questions so that it's easier for you to... Yes, yes, please. Sure. Here. Yes.
So you brought about Aadhaar being a major, which kind of brought the country together. If you see, Aadhaar is being used to, the big thought process was that India is a leaky bucket of social incentives given to the lower strata. And the fact that if you could highlight some of the absolute numbers by which Aadhaar has been a success, because on the other hand, when you go to apply for any social service, you want to get your license renewed, or you want to open an account with Airtel Bank, the fact is that that same universal ID data is not something that you allow the private sector to leverage. And with what the lady said on consent, today if I've downloaded an app which basically allows me to see the calories I've lost, but when I say yes, it says that any enhancements which come in later, you've already said an approval. So to the point she said, they've taken a universal approval and they can then do so many other things, but the consent is given. So how do you protect the consumer?
Yeah, we have, we'll take one more question and then I'll do another round. Yeah, exactly. Yeah, one.
Sir, I wanted to ask what your thoughts were about the approach that the recent draft e-commerce policy has taken, and how you think that that reconciles with some of the privacy framework principles that you talked about, that you want to build a framework that is harmonious internationally, globally. How do you think that reconciles with the policy, e-commerce policy, that talks about retaining data here, creating sovereign rights over that data, and also in some circumstances overruling consent in terms of what can be done with that data?
Okay, thanks.
In the light of, so that I don't forget it.
Yes.
So with the wearables, madam, the thing is very clear. If you go to the definition part of what is personal data, it need not even be a wearable. It could be a AC or a thermostat or a geyser or whatever. If any data which can be related to you, that's your personal data. It need not be on you. So wearables are very, very closely personal, but it need not even be personal. Like it could be like you could control your car garage from your phone or whatever. The fact that your sensor in your garage is giving data about whether the garage is open or not is your personal data. So all the protections which applicable to your personal data is applicable to that. So we...
But the issue is the clauses on offense to be handled. It says if somebody knowingly, intentionally, or recklessly obtains, processes, sells personal data or sensitive data or re-identified data.
No, I'll come to that. See, as of now, there's only one provision there which can take you to jail, which is like de-anonymizing anonymized data. This is the only penal offense in the draft bill. It may change, it may even go, or it may add. But the point is, if somebody sort of violates your privacy and your wearable data or device data is being used without your consent, you can take them to the regulator and you will get compensation and he will face a penalty. These are well within the existing draft. So it's not, you don't need to take him to jail or whatever. And about the consent part, again, I think I'm forgetting the question, madam. What was the question on the consent?
I said that the consent
On the app, etc.
Consent sometimes is assumed.
Yeah, so no, see, on the consent part, a lot needs to be done after the law comes into place, and then the regulator comes in and brings out how they should be dealt. For example, consent should be in as many languages as possible. Consent should not be written by a lawyer. Today, what you see as a consent is a standard legalese document. I mean, I could be uneducated. I need a visual thing. कि ये data मैं दे रहा हूँ तो ये क्या हो रहा है? It should be text, it should be audio. So all those things will come out, and I'm not interested in the legal language. So, and I should be informed. I give my okay to share my location. Now, you share with some hotels in Lucknow or whatever, you should tell me. Or I should go to a place and see the data, the consent which I gave. So there is a need for something in future like the consent dashboard. See, if you have a phone, probably you're giving hundreds of consents round the clock. Kisko kab, kitna, kahan, kya consent diya? So how do you find out? You can't go to each app and find out. So there could be some sort of a consent dashboard where you can go and say, tick. Like today, you can go to a bank app and say you can shut down your card. You can go to Aadhaar and say I'm now deactivating my Aadhaar. So nobody else can do that authentication. Now, some sort of a consent dashboard could be one place where all this will fall into place. So consent, there is no relaxation. Consent is, nobody can sort of take one omnibus consent and say I've given you this service, so lifelong I'm going to misuse it or whatever, and it can be revoked. So that's it. About the Aadhaar, I am fully with you, sir. It's a fantastic identity program. We can be much more ambitious or imaginative after the court order, because we had a court order which could have said Aadhaar is illegal. No, in that sort of a background, we can't think positively. Now, you've said about targeting welfare schemes. Now, just loudly thinking, I can think of a much better application, elections. Like if you have an electoral roll where it's linked to Aadhaar and there's only one person's Aadhaar across the country, I mean, imagine the effect it could have. That's something which probably we can look forward probably by the next few years. So applying Aadhaar for welfare schemes, for even private companies to use authentication on a voluntary basis are very much in line with what is coming out of the Supreme Court order. And probably after June, we could have a bill to replace this ordinance, and then things will move forward, I guess. Sir. And about the e-com policy, I would only say, we had this concern even when we discussed the privacy bill, because as I said, everybody owns data. Everybody says data is our business. But as I said, this law focuses on a law and a regulator to enforce the privacy of the individual. To that extent, this bill and this law and this regulator will work. Where it will have to rely on others is on the specifics of sectors. Like if RBI says, in respect of financial data, now this is what I want something to be done. As far as the privacy and the protection and the law is concerned, this law can stand. But in terms of the nitty-gritty of that sector, I think RBI should have the last word. If the health people say something about the genetic data, this should be the sort of the approach. So similarly for the e-commerce thing also, if their draft sort of impinges or overrides or something like the consent, privacy, etc., to that extent, that is an overlap which should be corrected. But if it's hardcore about trade or business practices, probably that doesn't concern privacy. So I'll only say it's work in progress, and I'm sure that we will also engage with them to take it to the logical conclusion. Sir.
Okay, I think there were other questions. Maybe I collect quickly one or two questions and then close this session because we are already running half an hour late. So just last round of questions, and could I request you all to be really brief? Please go ahead, quickly, Rajkumar. Yes, please.
I'm Aprajita, I'm from Ikigai Law. So I wanted your take on contractual versus fiduciary relationship between a data controller and a data subject. In the former, do you think a contractual relationship where a data controller says, I've taken your consent, I can do whatever I want now works, versus a fiduciary relationship in which the data controller has a responsibility to use the data in a non-pernicious manner? Also in a contractual relationship, the PDP bill speaks of consent should be capable of being withdrawn. How does that work in examples such as Truecaller, where I have consented for the use of data of my entire contact base? in the example of Alexa, where I have consented for Amazon to listen to me, but what about the guests coming to my house?
Yes, please, there was a question back there. Yeah. And then Prashanto, and I close after that.
Thank you for addressing us. Do you think that there could be culture-specific regimes of looking at privacy? And in that light, how do you look at data localization as a strategy, as an emerging regime? Secondly, what are your views on ownership of data and commercial exploitation of data by users themselves? And thirdly, what do you think about assurances of privacy by design by people who are the industry? Thank you.
And this is the last question, please.
Okay, you already mentioned several, the RBI example, etc., where you said the RBI should really have its say in the financial matters. My question is really that we've seen a number of policies, tweaks, etc. The RBI data localization, April 6 last year, the e-commerce policy, which this lady asked you about. My question is that with all of these overlapping significantly in multiple areas, where do you really come to? You could say on financial matters, it's RBI. Now, the e-commerce one is very significantly, more than a e-commerce policy, it seems to be a policy on the digital economy. It speaks about data, the economic value of data, data is the new oil, etc. So, where do you see this synergizing with or overlapping with? And I'm wondering if Mathews have had a significant part in that policy on the digital economy.
I think we should be fair to the rest of the speakers. I'll just jump through the responses. Yeah? Contractual versus fiduciary, it's only fiduciary. We look at it as a fiduciary thing. About consent revoking, yes. Whether before you enter into an interaction, he asks your consent, he says, I will use it for such, fine. Tomorrow you find that your number, your contacts, he is sending to all and sundry and misusing it, you very much have a right to withdraw consent. Having given one's consent doesn't mean that it should not be revoked. And culture-specific practices, I didn't understand that, but data localization, look at it this way. This is what when I meant. In the privacy policy, what is data localization doing? If it is felt that to protect privacy, this would be a good way of doing it, localization finds a place. This is across the country. Now, because if there is no safeguards, sensitive data is residing somewhere over which the NSA of some X country has access, but we have no access, then there's no guarantee. So that's just a simple example, I thought. About ownership and exploitation of data, see, data may be something which you own, but in terms of the privacy bill, it looks at data, just like her question which I had responded, as something which I as a subject give it to my fiduciary, and the relationship is that he holds it in trust. Not that I sold it to him, we've had slavery in this country and across the world, so that doesn't mean that you can't sell your data. But the point is, in terms of protecting privacy, you look at it more from the fiduciary relationship. And about privacy by design, yes, sir, it will come. It's just that, the data collectors, the data processors behaving responsibly with data itself is something new. We have so many cases of this often called breach of Aadhaar data and stuff like that. What has been breached is some ministry, some government, some industry, some entity, somebody sort of puts in the public domain Aadhaar data, mobile number and all those things. Not that Aadhaar is breached. So the point is, people have to realize that they have to handle it with care, and there are penalties for misusing. You can't get away saying, "Arey mujhe malum nahi tha, to privacy breach kar diya." So it requires a behavioral change in terms of people who are handling data over the next year, and that is why whenever the law comes, there's going to be a period of at least 1 year before it kicks in. Because a lot of processes have to be changed in government, in companies, etc., about how you handle data. So that's what I said. And about this e-com thing, sir, there is a role for the sectors, because in terms of sectoral regulators. But if you have a grievance on privacy, I don't think the e-com law will come into place. You have to go to the data privacy law, and you got to go to the regulator or the court to find relief. In terms of business practices or something else, maybe e-com policy will fit in. But if your privacy is violated, I mean, for that particular medicine, this is the issue.
Thank you, Mr. Gopalakrishnan. I think that was a wonderful special address, and we're really thankful for you to taking out time and coming here and address. No doubt we'll keep coming back to you with our questions and queries in the process of doing our research, and we'll be grateful if you, like in this time, spare your time with the research. So thank you all very much. I'm not going to say anything because we are running late on the next session. May I request the panelists for the next session to please come on the stage, and the moderator to please begin the session immediately. Thank you all very much.